Okay, so we have till now explored what is online gaming, issues around legality of online gaming in India, regulatory issues around the tech laws, and now in this fourth episode, we will explore very briefly though the issues around some more important sides of law relevant for online gaming. Hello, all of you. My name is Amol Lapte, and this is Lex Prudence podcast. If you haven't heard the content of this channel, please search Lex LEXPRUDENCE on Spotify or Google Podcast and give it a try. There are some old episodes that I had shared on certain interesting legal issues and topics, and I'm sure you will have fun listening to those. And obviously, this season is also available on YouTube now. We have been exploring online gaming as an industry in India. In this episode, we'll try and quickly touch base on issues like IP, finance laws, more specifically connected with the payments, e commerce guidelines, consumer protection, and taxation. I know these are fairly diverse subjects and may need separate discussions on each one of them. But since the intent of this series is to simplify and highlight important areas of law concerning the online gaming industry, I will cover one or two most important points under each one of these and we'll move ahead. So let us begin. And the first and the foremost thing that I wanted to discuss in this episode was intellectual property rights. Now, depending on the business models and type of online gaming offered, different IP issues may crop up for the online gaming operators, starting from, say, registration of their own trademarks, copyrights, and if required in some cases, patents, to licensing of various IP rights uh, from third parties, that is to say, the relevance of an effective IP policy for an online gaming operator is therefore immense. Using certain images and trademarks and all that, you have your joint ownerships of IPs where you are probably entering into contracts with development of an IP, which is a joint sort of an IP, and therefore the joint IP ownership issue comes forward. You probably are doing white labeling for some third parties, and therefore you may want to retain your own rights in the platform itself, but the branding of that platform may happen for the third party or vice versa. And similar kind of concepts attracts IP related issue for the online gaming operators irrespective of what kind of game they are offering. Since these businesses are online in nature and rely heavily on the digital marketing and promotions and those kind of stuff, not only registration and licensing of IP is important, but at the same time, effective strategy for monitoring your IP, enforcement of your IP, and obviously the litigation for the protection of your IP rights is a must. And therefore, it's an important thing or important matter for an online gaming platform to create a wholesome IP strategy for its business. Right from identification of IPs, registration of those IPs, moving forward from registration, monitoring whether there's any violation happening in the online space or no. Then, if you come across any violations, then the enforcement, and last but not the least, litigation. So, when I talk about the enforcements, typically it covers the takedowns and all that in the digital world. So, that's the holistic strategy that everyone will have to kind of at some stage start thinking of and creating as a IP policy. Now, let us take an example of fantasy sports and look around the business from different angles and from the point of view of information, uh, pardon me, intellectual property rights. Uh, so, A use cases on the product itself, the fantasy sports companies use the player mugshots, they use player names, and some statistics, all of which are different areas of IP in themselves. Independently, they are different IPs. So, player image itself is an IP. Uh, Image taken by somebody is an IP for that person. The player's image is an IP for player himself or herself because it's a personality that is being captured. The player name is also an IP. And then the statistics, while there are some laws around statistics and there are some judgments around statistics, but analytics, so to say, may have sometimes IP included in it. Now, depending on the use cases of the license requirements, you will have to consider, and contracts will have to be accordingly dealt with. So if you have a use case of, say, uh, only providing mugshots names or first names along with some bit of statistics, the strategy will be different. If you want to use a player's mugshot or an image along with his name to promote your brand, the strategy and the contracts will be very different. So these are some of the use cases. So the FS typically depends on the use of certain personality rights also relating to certain celebrities and players. And it is important to review the use cases vis-a-vis the rights that you are either licensing or not licensing. So on the commercial arrangement side, the large fantasy operators have sponsorship arrangements with teams, leagues, uh, for the purposes of usages of their marks, their names, and so on and so forth. On the operation of uh, fantasy side, they may again have sponsorship rights. They may undertake white labeling of kind of contracts. They may also uh, operate the fantasy for the league, and therefore the IP rights and the arrangements between the league and the fantasy sports operator will be very different. If you are operating, as I said before, if you are operating a white label solution for a particular league, then all you are doing is providing the backend technology. And therefore, the license that you may want to retain via the contract is the license, or rather the right or the ownership in the backend platform that you are providing. Whereas the front end is going to look like, or is going to be branded like, the league for which this white label is created. And therefore, there are different sets of IPs belonging to both the parties, and the ownerships vary from case to case basis. Now, so if we start looking at various areas of particular business, we'll find different areas where different use cases are found. And one needs to see the ownership of the IPs, the licenses given and taken, what kind of licenses are given, and then decide the strategy around the IPs. Also, the contracts where certain software development related activities is being taken over, then you need to figure out whether you're selling a SaaS based product, or you are creating a customized product, or you are just working as a developer on work for hire basis, because all three cases will have different rights and obligations flowing into you. If you are a SaaS provider, you fully own the license of the product, and the only thing that is getting transferred to a user or a customer is the license, or a limited license to use the software on as is various basis. Whereas if you are working as a contractor developing a platform for somebody else on work for hire basis, then all you get in that is the contract fee or the development fee, and no IP at all, because you are working for hire on the instructions of a third party. So these kind of things will have to be seen basis the arrangement that you want to enter into. Now, I know the IP is a very large area, but keep in mind that it starts with your own IPs, trademarks, copyrights, patents, designs, etc., that you register. First, identify and then register. Also, identify the different classes in which you want to register your trademarks. Then, monitoring those across the platforms in virtual world, or even in physical world in some kind of cases where it is merchandise and all, you will probably have also end up monitoring it for from a physical use case point of view. Then if you find violations, then there comes the enforcement, and then finally the litigation. Now the second set of law that applies to online gaming, and again I'm reiterating that I'm discussing these in very brief. If somebody wants to know certain things in detail, you may reach out to me, you may write into the comments, and we will connect. Now, second set of laws that I want to discuss are payment related laws, which is payment settlement systems, and PAPG guidelines, which is payment aggregators and payment uh, gateways related guidelines, which are issued by the IRDA. We are not going to get into the details of PAPG guidelines per se, but PSS, which is payment settlement system, and PAPG have of late become even more important. And I'm saying even more important because PSS was anyways very, very important for the platforms. Now it becomes even more important for the platforms which are real money gaming. And why it is important for the real money gaming platforms? Because you have money coming into the platform in the form of entry fee and stakes paid by the users, and then you have pooling of that money in an escrow or any other arrangement, similar arrangement that you may have created. And then at the end of the day, there is a discharge in terms of distribution of winnings among the winners. So it's a flow of money from point A to the platform to point B. And therefore, it becomes very, very important that you are aware of the provisions which are provided under the Payment Settlement Systems Act. Now, online gaming platforms, especially the RMGs, as I said before, need banking partners along with multiple PAPG partners to process the payments and distribute the winnings and carry out all activity which may have potential of falling foul to requirements under the Payment Settlement System Act. It is thus important to analyze and assess all your payment flows, the product flows, the money entry points on your platform, and how money is exiting, so that you make sure that your platform is duly complied with the PSS Act. Now, the platform actually needs to make sure that they are not carrying out any transaction in such a way that it has a potential of qualifying them as payment settlement system. Because, mind you, if you want to be a payment settlement system, then the PSS Act mandates an RBI license. Of course, there are certain exceptions out there, but without those exceptions, you will need an RBI license to carry out the payment settlement activity. And therefore, it becomes very, very critical for you to see that you are not actually becoming a payment settlement system. Now, what is this payment settlement system? In a very layman's language, a system that settles payment between two different entities. So it's not a typical activity of a buyer and seller where I am a seller and I'm selling you something and against which you are giving me a money. That's not payment settlement. But if I'm sitting between a buyer and seller and collecting payments and distributing it to the third parties and settling payments between these two parties, there is a possibility, again, as I said, except for exception, there is a possibility that I may qualify as a payment settlement system. And therefore, it's important for you to look at all your platform flows, payment flows on the platform. Now, in case the platform, in addition to online gaming services, is also engaging in buying and selling of, say, uh, assets, gaming assets, merchandise, uh, and some sort of e commerce activities, then in order to be duly compliant with the relevant guidelines, one needs to be either engage with PAPG services which are duly registered with RBI, or take the PAPG licenses to the extent of the payments portion of your platform. So, recently it was mandated for all e commerce platforms to either get registered with RBI as PAPG or outsource that payments portion to a registered PAPG platform. So, that's another important thing. If you're engaging in e commerce activities also, then make sure that you register or outsource that activity to a registered PAPG platform who's registered with RBI. Sometimes the platforms also have loyalty benefits, uh, discounts, and to carry out these loyalty benefits and discounts, platforms use some sort of digital coin or some sort of a currency in order to make sure that they know how much is to be given to their users. Now, these structures also need to be very, very carefully evaluated, especially when you are entering into contracts with third parties to make sure that the loyalty benefits are passed on to your users. Why I am saying that you need to engage and see very carefully uh, that you are in compliance with PSS Act is because again there are multiple parties getting involved in terms of entities who are satisfying the ultimate loyalty benefit given to the user. It's you, it's your user, and not only one user, it's multiple users from where the money is flowing in from one end, getting out from another end, benefits getting accrued at one end, dispensed off with another party at another end, and therefore all these flows within the system and outside the system with third parties have to be reviewed very carefully to make sure that there is no violation of PSS Act. The third is to be touched very briefly, but that's e-commerce guidelines. As I said, e-commerce has a different set of guidelines, especially when there is some foreign direct investment in the business. Then the e-commerce platform guidelines in terms of marketplace, in terms of uh, uh, inventory kind of a model is very, very elaborate and prescriptive, and therefore it's important for you as a platform to make sure that if you are an e-commerce platform or if you are falling within the category of an e-commerce platform, then you are duly compliant with those guidelines as well. I'm not dwelling deep into the e-commerce guidelines here because it's slightly different business altogether than the online gaming. The third piece that I want to deal with in this episode is consumer protection. Obviously, because you are a service provider and you are providing gaming services to a user, and the end user is consuming your services at a price, the Consumer Protection Act comes into picture and you become liable for compliances under the Consumer Protection Act. Now, all OG platforms are providing gaming services, as I said, to their end users, and therefore there is a relationship of consumer and the service provider between platform and the user, and the provisions of Consumer Protection Act will thus become applicable. Now, what do you need to do is to make sure that you have a robust consumer grievance redressal mechanism on the platform so that any dispute between you and your consumer is resolved then and there rather than getting escalated to the consumer forums. Also, you need to have robust policies created towards refunds, then communication in terms of change of terms and conditions, terms of use, what are the scenarios under which the user may be penalized, etc., etc., will have to be communicated very, very transparently and vocally to the consumer so that he's well aware of all the terms and conditions that apply to him while transacting on your platform. What this does is that it makes sure that user is adequately made aware of the terms that he needs to follow while transacting on the platform, and there are lesser and lesser chances of anything converting into a dispute. The other thing, as I said before, is post that have a very, very robust consumer grievance redressal mechanism so that the first step for a consumer is to approach you rather than directly approaching the consumer protection forums, because then it converts into a litigation and the possibility of resolving a dispute amicably drastically reduces. The next one that I want to discuss is advertising guidelines. Now, there are certain guidelines prescribed in the Consumer Protection Act. There are certain guidelines prescribed by ASCI, which is a self-regulatory body and kind of a self-regulator for the advertisements. There are certain guidelines prescribed by Ministry of Information and Broadcasting, especially towards the advertising of gambling and betting. Also, the gambling acts across the states prohibit advertisements relating to gambling and betting within the territory of their states, and therefore, all these put together will have to be followed by the platforms. Now, typically, ASCII has given a set of guidelines to be followed, and there are certain disclaimers that are required to be put on the advertisements, similar to what you would have seen on mutual funds, insurance, and other financial products, where there is a last end slide of an advertisement is nothing but a disclaimer. And similarly, ASCII has also recommended a disclaimer. We will have to put those disclaimers. The Ministry of Information and Broadcasting has also, from time to time, given certain guidelines which have to be followed. And make sure that when you advertise and market your product, you are duly in compliance with those. Now, while ASCII per se does not have any enforcement uh, powers because it's a self regulatory body, however, it has got due recognition from the Ministry of Information Broadcasting, and therefore they also have a broad reach. So it's not only the advertisers who are on their platform registered with them, but also the broadcasters, also the digital media platforms. And their reach has recently been increased to digital media platforms and all other forms of advertisement. And therefore, they have a far reaching uh, scope, so to say, or jurisdiction, so to say, when it comes to regulating the advertisement. The last but not the least that I want to discuss today is taxation. It's a very, very deep subject and it's a very, very detailed subject, and therefore, only two updates here. Last year, there were two changes that were brought in. A, with respect to how the deduction or at source, tax deduction at source has to happen for the winnings from online gaming. You need to be aware of that and update your systems accordingly. And two, introduction of 28% GST on the deposits was introduced last year. Now, what does that mean? That means that you will have to look at your product flows again from the point of view of deposits, discounts, cash bonuses, withdrawable amounts, what can be withdrawn, when it can be withdrawn, and how the calculation works at each of these stages from the GST point of view. Also, TDS has become a net net off kind of arrangement now without any threshold of 10,000 rupees. So you will have to probably change your formula also if you have not done it already. It's been a year now, so I'm assuming that everybody has done it. But if you have not, then the formula will need to be tweaked to make sure that you are in duly in compliance with the Income Tax Act in terms of deduction of tax at source when you disperse the winnings to your users. Okay, so we have quickly touched base with some of the important laws around the area of IP, finance, taxation, and consumer protection, and got a brief sense on what all do the operators need to take into consideration to stay compliant. So, friends, we'll end our third episode, or rather fourth episode, of Lex Prudence online gaming series at this stage, and we'll catch up again next week with the next episode where we will discuss various legal issues around the industry other than whatever we have discussed in last three episodes. We'll touch base with something around the governance issues which are now starting to creep up in different state laws. So governance is an important issue and we'll discuss it in the next episode. If you have any questions, please do let me know through your comments. You can also write into me at lexprudence2020 at gmail.com and I will definitely try and answer your queries. So catch up with you next Friday. Till then, take care and namaskar.